Hi guys, welcome back to another video. So I hope I am audible to everyone. And also, this is a new video for episode 5 that we have taken out for your legal current affairs. So if you are new to the channel, please make sure that you are subscribing to our channel and also liking the channel for the same reasons. Now the first news for the day, that if there is frivolous litigation, it can be put to an end at any stage, right? So that's what the High Court has done while dismissing uh, a plea by a vendor who was selling vegetables in Delhi itself. Now, the first thing that came into was that the judicial institution is grappling with a huge pendency of cases, right? So, if you see that there are crores of cases that are pending in front of the High Court, Supreme Court, and different courts all across the country. So, this is because there are a lot of frivolous litigation. That means that litigation which is not correct in nature is there existing in these cases, right? So the Delhi High Court has said that an endeavor must be made by the courts to dismiss the same on very first date without any further delay, right? So the court has said that you can just dismiss this kind of a petition at any point without taking up any delays, right? They shouldn't take this very seriously, and they should dismiss it on the very first date itself as soon as it is presented in front of the court. Now, the second point is that adding to such frivolous litigation should be nipped in the bud, right? That's what Justice Dinesh Kumar Sharma has said, that the courts do not have the luxury to continue with such cases which are frivolous on its face merely because certain procedural motions have to be undergone, right? So they are very clear about it that they don't have the time to take care of such cases which are frivolous in nature, and also because certain procedural motions have to be undergone. That means that they have to take those steps in order to make those exemptions and dismiss the case in the future, right? So they should stop it as soon as they see it on the very first day, as soon as it is presented in front of the court, right? Now, coming to the next point, if for some reason such orders are not initially passed in a frivolous litigation, nothing stops the court to put such an order to at any stage, right? So they can put it to an end at any stage. That means that if they are not able to find it in the first few proceedings, they can also quash it in the future, right? So that's what the court has said. Now, it was also observed that the cost must be that illegal and unauthorized litigants may not be given an opportunity to misuse or abuse the judicial process. So we have seen that people who don't come with clean hands, right? The people who are leading to that nature that they will put on frivolous litigation or misuse and abuse the judicial process. The court has to bear in mind that many honest litigants and bona fide claimants remain pending, and the system is clogged by frivolous litigation and mischievous litigants, right? So it is simple that because of these kind of people there is so much delay in the justice system of the country. So they need to keep these things into serious check, because we are such a country which is not able to get to the highest level of productivity for their litigation system. So that is what is being said here. Now coming to the next part is that Justice Sharma also opinionated where the petitioner failed to assert his legal claim, title or interest, or there is no pleading or assertions, there would be no purpose of continuing with such a trial. In this regard, the court is also to see the purity of litigation pending before it. The relief of injunction is relief of equity. Ones who claims equity should come with clean hands, right? So simple as that. If you are not coming to the court with clean hands, your case will definitely come under the consideration of frivolous litigation, and it might lead you to be dismissed on the first hearing itself. That's what the court is saying here. Now, coming to the next part, that there was a consumer of Uber, right? So all the taxi services that we use, Uber, Ola, Rapido, there are a lot of services of that sort that are available in the country. So there was a consumer in Mumbai who has held Uber like liable for the driver's negligence leading to missing her flight. right? So that's a very common thing that can happen with any of us in this country, right? So this was a lawyer who was traveling in Mumbai and she missed her flight because of the negligence of a Uber driver, right? So now there was an aggregator responsible for the driver's negligence in the Consumer Redressal Forum in Thane directed Uber India to pay lawyer rupees 20,000 for a missed flight to Chennai owing to the delays caused by the driver, right? So the court has held the cab aggregator responsible. That means that Uber is responsible for the driver's negligence, and the Consumer Dispute Redressal Forum in Thane has said that it will the driver has to be held punishable, and also the payment has to be done by Uber India. Right now, coming to the next part, that the forum held that the complaint was Uber's consumer under Consumer Protection Act of 2019, and driver was merely an agent that was appointed by the cab aggregator, that is Uber itself. Right, so now we have seen and we have used Uber for a long period of time, so we can see that these kind of cases can happen. Now it is provided that the third party contractor is appointed and managed by the opposite party for providing services to the complainant. Therefore, we came to the conclusion that the complainant is the consumer of the opposite party, and the opposite party provided services by appointing driver as an agent and received consideration from complainant. A three-member charge of the President R.P. Nagre, members GM Kapaseda and S.A. Patikar. So that's what is being said here, that the person who is the aggregators of the cab, we have to see that they will be held responsible, okay, because the agent is the person who is driving the car, that is the driver, and he's a third party contractor, okay. So now coming to the next case is that the right to contest elections, right, is only a statutory right, not a fundamental right. Now this is something that has happened in the Andhra Pradesh, and it is very territorial in nature, but definitely this case can help you understand further how the rights and the constitution are working in our country. Now the Andhra Pradesh High Court has reiterated that the right to contest elections is a fundamental right, but it is only a statutory right. Now the observation was made by a single bench of Justice Chikati Mandarathar Rao in the context of AP Societies and Registrations in Act of 2001. Okay. Now coming to the next part, that the petitioner in this case submitted that he was an employee in the revenue department of Andhra Pradesh. Okay. Now coming to the next part is that the secretariat and was working as a section officer. It was his case that he has submitted his nomination for the post of secretary in the election which was scheduled to be held for electing the officer bearers of the executive committee of the Andhra Pradesh Secretariat Section Officers Association. Now, however, despite his name appearing on the voter list, his case was the respondent election officer rejected his nomination, right? His name was on the list, but his nomination was rejected. Okay, as the serial numbers in the voters list were published, but his name was not in the tally. Now, in connection with the question that was placed, right, whether the petitioner could invoke the extraordinary jurisdiction of the High Court on the reliance placed on Section 23 of the AP Societies Registration Act of 2001, it is finding in the case the petitioner was aggrieved by an order of the election officer, he could challenge the said decision or election only by way of making an application under Section 23 before the district court concerned, which is as per Section 2D of the Act, was the city civil court in the cities of Hyderabad and Secunderabad and principal civil court of original jurisdiction elsewhere. Now, the right to contest elections, that was the court has said that right to contest elections is not a fundamental right. Okay, it is a statutory right. Therefore, it cannot be said that it is a fundamental right of the petitioner is violated, and seeking enforcement of the same that presents writ petition is maintainable. Right. Coming to the next part is that Punjab and Haryana government has agreed before the High Court to consider a plea for setting up transgender protection cells. Now, the Punjab and PNH High Court has disposed of two PILs for setting up transgender protection cells in two of the states. The petitioner Dhananjay Chauhan has sought formulation of comprehensive policies on measurements and procedures for protection of transgenders in the respective states. Now, it was the case of the petitioner that had earlier approached the authorities in both the states that representations as well as emails, but to no avail, right? They didn't respond. Now, respondent, that is the states of Punjab and Haryana, respectively submitted that they shall consider the representations of the petitioner and shall decide the same expeditiously in accordance with the provisions of the law. Now, the division bench of Chief Justice Ravi Shekhar Jha and Justice Arun Palli, after hearing the submissions of both the parties, disposed of the petitions and stated that the respective authorities would be at liberty to examine the matter, taking all the facts into consideration, and therefore they shall accept or reject the same in accordance with the provisions of the law. Now, Google reviews, right? We all put reviews on the internet. So Google reviews have no legal evidentiary value and can't be used to argue that the accused is of habitual offending in nature, right? He's an habitual offender, right? So uske business ke reviews obviously can be on the Google review platform. So you cannot be said that if you're reading the previous reviews that yes, this person has taken up some fraud or done something. So these reviews cannot be taken as legal evidentiary value. So the Karnataka High Court rejected the argument that the Google reviews against the accused show that he's an habitual offender. By holding that Google reviews have no evidentiary value, the court has also said that single Justice Rajendra Bhimkar bench said thus granted anticipatory bail to the 71-year-old Om Pratap Singh, who was arrested in the case of impersonating in business, right? He was booked with charges under section 490, 420, that is also misrepresentation, cheating, right? And under section 66C and 66D of the Information Technology Act because of the reviews that he had. Now, the complainant who was in the business of lamp oil, right? The person who was accused, right? She claimed that she paid the accused 52,39,400 rupees in two installments, but the later supplied the goods worth of 26,031,611 rupees only. Now the petitioner said that because of the Russia-Ukraine war, there has been a lot of disruption in the supply chain, so he's not been able to make the delivery. And also he submitted that an amount of 8 lakh rupees was returned to the complainant, and the remaining amount of 16 lakh which stood invested would also be returned in the due course. Now, rejecting the argument of the prosecution, the bench said the argument addressed by the learned HCGP that the Google search disclosed that the petitioner has cheated a lot of numbers of people is of no evidentiary value and cannot be taken in as a legal evidence, like a legal evidence. Okay, so that's what is being said. Now, widow and a widower, right? A person who has lost his wife and a person who has lost his husband, right? Live-in couple, right? There was a widow and a widower who was in a live-in relationship. The couple was granted protection by the Rajasthan High Court, saying privacy and the liberty of individuals cannot be infringed. Simple as that. If I've lost my wife or if I've lost my husband, then it's my private matter, right? If someone goes and starts living with another person who is of the same status, then there's no difference, right? So there is a right to privacy and they can live together because there's no valid marriage at that point of time. So, coming to the first part, the Rajasthan High Court, disposing of the petition that was filed for protection of life and personal liberty by a widower woman and a widower man staying together in a live-in relationship, observed that the petitioners have the constitutional right to privacy, liberty, and also choice, right? Simple as that. They also moved to the High Court and filed a petition under Article 226 of the Constitution for protection of their life and personal liberty. It was their case that they were widow and widower respectively and were together in a live-in relationship, which was opposed by the private respondents being the family members of the first petitioner. Okay, aggrieved by the non-approval and non-recognition of their relationship and subsequent threat to their life and personal liberty, they prayed for protection before the Jaipur bench of the Rajasthan High Court. Okay, so there was a lot of threats that were given to them, because obviously if you are doing something unconventional in nature, there will be a lot of people who will come up and start questioning you for the same, right? So that is what it is. So they also came in front of the Rajasthan High Court and they asked for a remedy for the same. While recognizing the petitioner's right to privacy, the High Court highlighted how it must be guided by the conceptions of constitutional morality and not by the ideas of society or societal morality, right? So there is no set standard for societal morality. Earlier there was no live-in relationship, now there's live-in relationship. Earlier there were no divorces also, now there are divorces. Earlier there was a lot of stigma related transgenders and lesbian and gay couples and all those things, which was obviously there was no constitutional morality on that, but there was social morality that was construing all those things, right? So here the court said the same, that it must be highlighted that how it is guided in the concept of constitutional morality and not how society wants it to be, right? By relying on the Supreme Court decision of Navtej Singh Johar versus Union of India. Now furthermore, the court also relied on the Supreme Court decision of Shafin Jahan versus Ashoka KM to recognize both individuals' personal choice and constitutionally guaranteed freedom over and above social values and morals, right? Social values क्या है, इंसान ने बनाया, इंसान के लिए बनाए हैं, right? So there is no set standard for that. So they have constitutionally guaranteed freedom, उनके पास freedom है, उनके पास एक right to privacy है, they can take their own choices, they can make their own decisions, they have all of these rights, right? So over and above the social and the moral values, these people can be given a freedom to take their own decisions. That's what the Rajasthan High Court has said, that to Jaipur bench. Now coming to donating of toys in the Angarwadi Kendras, right? Angarwadi is where a lot of people go and study, right? So that is the condition for the bail that was being approved by the Madhya Pradesh High Court in the dacoity case, right? So this was a bail condition that was given, that this order comes from Justice Anand Pathak, who resonated that this direction was being made by the court as a test case to address the anatomy of crime, violence and evil by the process of creation and a step towards alignment with nature. So that's what they said. And this direction is comes under because they want to ingrain attributes of human essence in that person. That is why they have given him such a bail condition. Okay, this is a great thing and this should happen definitely, because in the US, they say social service, right? You have been given as a punishment as a social service. If you don't have money to pay, go do social service. Simple as that. So they have that rule. So here it is being instilled in some or the other way now. Now coming to the next part is that habeas corpus, right? That is a writ petition, is maintainable in child custody matters when the detention of minor by the other parent is proved illegal. Okay. So if the person who is in the court proves that that the minor who's taken by the other person is a person who's illegal in nature, is the parent who's not able to take care, then such a petition can be maintainable. Okay, so the Gujarat High Court, by dealing with a plea that was filed by a mother of a minor child, held that the habeas corpus is maintainable. And also, they said that relying on the Supreme Court's judgment of Tejaswini Gaur versus Shekhar Jagdish Prasad, the petitioner had prayed for the issuance of writ of habeas corpus, directing the police authorities to produce her minor son before the court and hand over him to her. The allegations was that her husband and others snatched away their son from their hands on October 2 in 2021. The couple got married in 2013 and due to certain disputes, she left her matrimonial home with her son in 2019 and initiated the proceedings under Indian Penal Code and Criminal Procedural Code, that is the CRPC, right? And against her family members and the husband also. So now, in the connection with the question to the custody, the court said that whenever a question arises before a court pertaining to custody of a child, the matter is to be decided not on consideration of the legal rights of the parties, but on the sole and the predominant criteria of what would be the best serve interest and the welfare of the child. Now, the court also observed that the question cannot be determined by weighing the economic circumstances of the parent or their capacity to provide material and physical comfort, but on the consideration including psychological, spiritual and emotional welfare of the child. So you can see that they are thinking much more deeper than just the physical and the material aspects of comfort. Okay. Now this case, since the child was with his mother since she left the matrimonial home, the court ordered for the custody of the child in her favor. The court in 2021 had granted interim custody of the minor child to his mother only. So that's what is being said. So thank you for joining this live session. I hope you were able to get some knowledge about these legal and also some cases that are going about and all the newses that you have just read. So this can be something really important for you. So do make sure that you hit on the like button, and also don't forget to hit on the subscribe button, and also hit on the bell icon for all these regular updates. So thank you for joining this live session.